And finally, we will hear on behalf of the Customs and Immigration Union, Mr. Mark Webber. Welcome back, Mr. Webber, and please proceed whenever you're ready.
Thank you, Mr. Chair. Mr. Chair, members of the committee, thank you for inviting me to appear here before you today. As National President of the union that represents Canada's Border Services personnel, it's with great interest that I've been following Bill C-20, and I'm happy to once again have the opportunity to comment on this legislation. When this bill was first studied in the House of Commons, the Customs and Immigration Union highlighted several areas of concern to the Standing Committee on Public Safety and National Security. While the union is pleased that the committee went on to propose a number of amendments to address these concerns, several issues do remain, chief amongst them, which is the need for the legislation to ensure that our members can avail themselves of the recourses offered by the PCRC. Before I talk further about amendments to Bill C-20, however, I'd like to take a moment to highlight the importance that this bill plays in cementing the role of the CBSA officer as public safety personnel. The oversight proposed by Bill C-20 is certainly consistent with the role of CBSA officers as law enforcement officers, confirming their place within our country's public safety framework. It is not consistent, however, with other legislation and related processes that govern benefits such as earlier pension eligibility. Indeed, CBSA law enforcement personnel are at a disadvantage compared to their peers working for other similar agencies, as they must work longer before retirement, often becoming sick or injured on the job, or unable to meet the physical demands of their work. When I first testified to the House Public Safety Committee about Bill C-20, I asserted that it was crucial that this inconsistency be addressed before the bill becomes law. We were encouraged in June when the government announced that legislation enabling such changes would be tabled this fall. We're looking forward to those changes in the very near future, and I do wish to stress how important it is that these occur before Bill C-20 is enacted so that the benefits our members have access to are consistent with the additional oversight resulting from C-20. Now to the amendments, as I've noted in the past, the agency is well known amongst its employees for letting gross abuse by management run unchecked, and it is difficult for CBSA employees to see complaints about managers go addressed through existing channels. In fact, CBSA managers often promote the very atmosphere that allows bad behavior to flourish. Thanks to the ArriveCan debacle, the lack of accountability within the agency's management is now infamous, and it is clear that CBSA's reporting and internal investigations, the structure badly needs to be overhauled. Just last week, CBC published an article regarding a case where CBSA was found to have deceitfully disguised its failure to conduct a proper investigation, which is really sadly the norm when it comes to CBSA management. I believe Bill C-20 could help address this by introducing clear language around an employee's right to report problematic conduct from superiors. We also have pressing concerns around time limits, notably when it comes to the initial time frame for filing a complaint. Under the latest version of the bill, complaints could be made up to 2 years after the incident has allegedly occurred. Given that CBSA officers often interact with hundreds of travelers a day and that these interactions can be extremely brief, exceedingly long delays would put officers subject to a complaint at a tremendous disadvantage, as recalling a seconds-long interaction that occurred months ago is often near impossible. To conclude, we have submitted a brief to this committee detailing our concerns with the bill, which we hope will be of assistance. I thank you and I look forward to your questions.